Good morning. My name is Liz Roussel, and I'm a partner at the Adams & Reese law firm. I focus my practice on defending employers and management in employment-related disputes. Today, we're going to talk about how companies are using technology to track their employees' work activities. We're going to discuss what technologies employers are using to collect data about their employees, what information they actually can collect using these technologies, and the way that they can benefit from the data that they collect. We'll also spend some time talking about some of the risks and limitations that are imposed by the use and collection of this data, and we'll also give a little discussion to some of the unintended consequences, and finally finish with a few takeaways. So let's get started by talking just generally about the type of technology that employers are using to collect data about their employees. It wasn't too long ago that an employee could go to the workplace and work there for years without their employer knowing too much about their work habits, what they did outside of work, and so forth. Unless, of course, they shared that information, chose to share that information with their supervisors or their coworkers. And it wasn't all that long ago that if employers wanted to know how employees were conducting themselves during the workday, they would rely on the eyes and ears of their supervisors to let them know, were employees getting up and doing their job? Were they meeting the company's expectations? Many employers also didn't use technology for operational purposes. They used sign-in sheets, for instance, for attendance, or maybe they'd use keys for people to gain entry and exit from the buildings. Today, of course, this is a very different story. Employers are routinely using technology to improve efficiency, security, accuracy, to measure productivity, and even to direct the work of their employees. They're doing this by using GPS technology, timekeeping software, and security access devices. Of course, sometimes employees themselves are using technology in the workplace. Many of them elect to use Fitbits or Apple Watches to track their own health. Of course, most jobs today require employees to use computers and smartphones. They have to use computers both when they're in the office and when they're working remotely. And in some workplaces, employers are actually using technology in clothing and in personal protective equipment. Some companies even give employees the option to use microchips under the surface of their skin. Last year, Gartner, Inc., which is a technology and a consulting firm, published survey results that indicated that non-traditional monitoring devices, like tracking your employees' movements around the workplace or gathering their biometric data, rose from 30% of the 239 large corporations that they surveyed in 2015 to 50% in 2018. It anticipated that that number would rise to 80% this year. So those are the technologies that we've discussed that employers are using to collect data about their employees. So let's take a look now, a little closer look, at what type of data employers can gather using these different types of technologies. With GPS technology, employers, of course, can locate their employees. They can determine the rate of speed that they are traveling while driving company vehicles, and they can also figure out if employees are using the most direct route to get from point A to point B. Employers who are no longer relying on sign-in sheets and punch clocks to record time worked may be using fingerprint devices to track when employees are arriving at or leaving from work, or they may use other computer software applications to do that. To ensure building security, employers may also be using facial recognition technology or even hand geometry scanners. As I mentioned before, more and more employees are using devices like Fitbits and Apple Watches to record their own biometric data, like their heart rate or their temperature, the number of steps they're taking in any given day. Some of them are even recording their sleep patterns. Of course, this same kind of biometric data is often stored on employees' smartphones, which can also be used as location tracking devices. With company-issued computers and laptops, employers have the ability to determine whether the employee's computer is turned off or on. They also have the ability, if an employee is working remotely, to know whether they are connected to the company's server via the virtual VPN network. They can also determine, of course, how long an employee is spending surfing the internet while they should be working. I mentioned previously clothing. Some company-issued clothing that is designed to improve safety can also capture biometric data. For instance, there's a company that makes caps that have the ability to measure EEG monitoring data, and they can determine, those caps can predict whether employees are suffering from fatigue. Those have been used in the transportation context. You may have also heard of smart fabrics, which are clothing that you can buy on the market now that measure the same kind of biometric data that, for instance, a Fitbit or an Apple Watch might. Finally, I mentioned microchipping. Believe it or not, there are some companies that offer employees the option, it's voluntary, to have a microchip implanted under the surface of their skin. And they can use their hand then to do things like log in to get past the building security, log into their computer, even pay for their food at the company cafeteria. And while this may seem sort of odd, in a post-COVID environment, you can see that this provides a contactless way of going about accessing and moving through the workplace and the workday. So let's talk about now the ways that employers can use all of this data for their benefit. As employers continue to modernize and use the best technology available, they necessarily are collecting data, but they don't have to use it. Nevertheless, there are many ways that employers recognize this data can be used for their benefit. So let's take wage and hour claims and compliance as an example. For those of you who are HR professionals, you know that wage and hour claims continue to be among the most popular claims brought by plaintiffs and plaintiffs' firms. And this is because these claims can be brought collectively on behalf of large groups of people, and they also carry with them statutory penalties and the right to recover attorney's fees. The Department of Labor also has continued to step up its investigative efforts with respect to wage and hour compliance. In 2019, the Department of Labor reported collecting $322 million in wages owed to workers. Often, of course, wage and hour claims involve allegations that employees worked time for which they weren't paid. Employers can use the kind of data that we've been talking about collecting, like determining when employees' computers are on or off, or determining when they are connected to the VPN or not, in order to verify the accuracy of employee time records, or perhaps to investigate demands of non-payment made by employees to see if they actually were or weren't working when they claimed to have been. Data that can be collected from smartphones and GPS devices in company vehicles can be used for the same purpose. You can use that GPS data or location technology in a smartphone to determine when an employee arrived at a job site, for instance, and when they left. You can use it to ensure compliance with mandatory meal and rest breaks if your employees are operating in a state where meal and rest breaks are indeed required. Or you can use that same technology to make sure employees aren't abusing the break time that they're afforded. Another way that employers are using data for their benefit relates to performance evaluations and incentive compensation. Let's take an outside sales job, for example. Employers could review data from a GPS device in a vehicle to determine whether employees are making their sales visits, whether they're covering the territory that they're assigned to cover, whether they're spending the necessary amount of time at the sales visit and the stops that they're making. They can incentivize employees to work longer hours, to cover more territory, and to make more visits by structuring their compensation system and in a way that incentivizes the behavior that they want to see. Some published studies have also correlated the amount of time that employees spend using their smartphones with productivity. Employers who have access to determine the amount of time employees are spending each day using their smartphone can use that data for disciplinary purposes or in evaluating employees' performance or measuring their productivity. Think about when you look at your smartphone, and if you're like me, you get a report at the end of every week that tells you whether you have more or less screen time than you had the week before. That's the sort of data that I'm talking about. Some employers, of course, have even more sophisticated means of analyzing employees' computer usage. They can do so by looking at their keystrokes or by visiting the different applications that they are using to see whether they are opening and closing applications or saving or creating files. That information, of course, can also be used to evaluate productivity and performance. This has become and may continue to be even more important in an environment where more and more employees are working from home, but their commitment to their job and their productivity can't easily be measured the way that it can be in some industries. For instance, lawyers can measure their time and their productivity by recording billable hours, but not everybody can do that. And so employers can use this access to computer information to confirm that employees are meeting their expectations when they're working outside of work. Of course, technology and collectible data, the kinds that we've been talking about, can also play a really important role in safety compliance. In some industries like trucking and transportation, companies have been using GPS data for these purposes for years. For instance, to make sure that employees are not traveling at unsafe rates of speed or that they aren't driving for more hours than the law allows. But using GPS and similar technology in company vehicles to track the employees' whereabouts and determine that they are on task is becoming more and more customary, and it enables employers to evaluate the safe driving and other behaviors of their employees in all contexts, not just the long-haul, over-the-road trucking context. Technology can also be used, of course, in this data that we're talking about to ensure compliance with other policies. Recently, many companies, as you all I'm sure are aware, have used software applications to ensure compliance with COVID-19 safety policies. You guys, I'm certain, have worked in workplaces where companies have come out with new policies that require you to be temperature checked and masked and so on and so forth before you can enter the workplace. Employees are able to use technology to examine their own biometric data, to look at their temperature, and also to answer a series of questions to make them make informed decisions about whether or not they should or shouldn't go to work, and specifically whether they may or may not be symptomatic for the virus. Some of the same devices that employees are using to monitor their health and wellness, like Fitbits and Apple Watches and so forth, are offering these same sorts of COVID-19 screening products. For instance, Fitbit has developed what they call a ready-for-work solution that monitors your temperature and your symptoms, and it allows employees to use a daily check-in feature to determine whether they should or shouldn't go to work on any given day. They also have the option, if they choose to share that data with their employers. So speaking of wellness programs, a number of employer-sponsored health benefit plans offer incentives to employees who take proactive measures to live healthier lifestyles. For instance, United Healthcare offers a program called United Healthcare Motion that gives participating workers up to $1,000 per year back if they hit certain goals, like walking 10,000 steps in a day with at least 3,000 steps taken within a 30-minute period. Blue 365 is a similar program. It's offered by Blue Cross, and it gives employees a discount if they simply purchase a Fitbit. And Aetna has a similar program with Apple Watches. Employees can choose to share the results of their efforts with their employers. According to an annual survey from the Kaiser Family Foundation, 14% of employers who offered health insurance in 2017 collected data from their employees using wearable devices. In 2018, that number was around 20%. And one tech consulting firm has predicted that annual sales of wearable devices for companies' wellness programs will hit $18 million in 2023. Significantly, if employees choose to share this data from their wearable devices with their employers, or they authorize Fitbit or Apple to collect it, it can lose its HIPAA-protected status. This means basically that employers can learn information about their employees' health and wellness that they previously never would have had access to. They can learn, as we've talked about the number of steps they're taking in a day, or their resting and active heart rate, their sleep patterns, and more. And if the information isn't HIPAA protected, then employers may be able to use it in ways that they otherwise wouldn't. And that's because HIPAA protects doctors and hospitals and insurance companies from disclosing personal health information, but it may not protect that information from the same disclosures if it's voluntarily provided to employers or to companies like Fitbit or Apple. Last year, the Washington Post actually ran a really interesting story about a plastic fabrication company in Texas. And it invited all of its employees to participate in its company wellness program and to share the data that they collected through an app on their phone concerning their health and fitness with the employer. The program was entirely voluntary. One of the employees returned to work after suffering from a heart attack and having triple bypass surgery. And through the app on the phone, his boss actually monitored his steps, and he would encourage him throughout the workday by sending him messages or making comments to him like, "Hey man, you're doing great today. You used to have 2,000 steps, now you have 6,000. Or I see you worked out 2 times this week, good job." When this employee was interviewed about this workplace health monitoring initiative, he didn't find it intrusive. In fact, he said that he appreciated it and found it motivating. In that instance, the employee was 51 years old. This employer in Texas also contained or maintained and published rankings. So there was sort of a leaderboard for the employees in the workplace to show who was keeping up with the app and who was performing well. And every quarter, the employees who were at sort of the top of the leaderboard would be eligible to get a check from the insurance company to keep them motivated. What I found interesting about this Washington Post article is that most of the employees at the Texas facility who chose to participate in this program and to voluntarily share this data with their employer were older. Fewer millennials chose to participate in the program. But one of those who did and who was interviewed about the program said he wasn't concerned about his data being used or collected or where it went. He viewed privacy as something that may need to be sacrificed for the benefit of using technology. So let's move on. Now that we've talked about the different technology that exists out there and the kind of data it can capture and how employers can use that for their benefit, let's talk about some of the risks and the limitations that might be associated with using the data. From an employment standpoint, the paramount concern, of course, is that employers will rely on this data that they can collect to make employment-related decisions. Organizations that advocate for consumer privacy are concerned that employers will rely on what they know about employees' activities outside of work or their health and biometric data to decide, for instance, who they're going to retain, who they're going to promote, or if there's a layoff, who needs to go. And certainly employers who choose to collect this data and who choose to use it are at risk of opening themselves up to claims that workers who suffer adverse employment actions will claim that the data that the employer had in its possession factored into that decision making. Employers can always defend against these claims by demonstrating that they didn't rely on the data that they collected. But what if they do? Is it necessarily improper or impermissible? And the answer is no, not necessarily. It really depends. For instance, in some cases, employers are clearly within their rights to use the data that they're able to collect to make employment-related decisions. Let's take, for an example, an employee who determines, or rather an employer who determines through the use of GPS technology that they have an employee that's constantly speeding on the job, or that's lying about the time that they're arriving at a job site or leaving work. It can take disciplinary action. Likewise, if an employer can determine that an employee is not actually working from home when they say that they are, because, for instance, they can see that their computer hasn't been turned on, or they haven't connected to the company's VPN, which is necessary for them to do their job duties. It can take disciplinary action. But employers can get in trouble if they use information that they haven't disclosed they'll be collecting. For instance, some states have laws that prohibit employers from placing GPS devices in employee-owned vehicles without consent. That seems unsurprising, but in some states like Illinois, it's actually a criminal misdemeanor. And one New York court held that an employer violated the law by placing a GPS device in its employee's vehicle when it was trying to determine if the employee was actually lying about their time worked. In some instances, it may be a statutory violation for employers to collect information even if they don't use it. I suspect that many of you are familiar with the Illinois Biometric Information Privacy Act, or BIPA. This statute was enacted in 2008, but it really didn't gain any popularity until 2015, when a series of class action lawsuits were filed, including one against Facebook and one against Shutterfly. Among other things, BIPA requires that employers obtain informed written consent before collecting any employee's biometric data. It only allows limited disclosure of the information, and it contains very strict obligations and guidelines with respect to what the employers must do with regard to retaining this information and destroying the information that's collected. It specifically prohibits employers from profiting from the use of the data, and there are statutory penalties for violation: $1,000 for a negligent violation, $5,000 for an intentional one. And most significantly, it contains a private right of action. Just last year, in 2019, the Illinois Supreme Court found that actual harm is not required to establish a violation or to sue under this statute. In one of the suits against Facebook, users of the social media platform brought a class action under BIPA, and they accused Facebook of collecting their biometric face information using a facial recognition software with no consent and with no notice, to use in Facebook's tag suggestions feature. That's a feature that identifies the faces and images that are uploaded to Facebook and then makes suggestions about how you might tag people. The only harm that the plaintiffs alleged that they suffered in that case was the statutory violation. Initially, the parties negotiated a settlement, and they presented it to the court for approval. It was a settlement in the amount of $550 million plus certain remedial actions that Facebook was supposed to take. But the court refused to approve that settlement, finding the monetary amount and the remedial action insufficient. Just a few months ago, the court approved a settlement in the amount of $650 million and other non-monetary terms. The same sort of claim under BIPA was made against Shutterfly. In that case, two consumers who used Shutterfly claimed that it violated BIPA by using its proprietary facial recognition software technology to locate every face that appeared in every photo, regardless of whether the people who were in the photo were users of Shutterfly's technology. In that case, we don't know what the outcome is going to be because the court recently ordered it in May of this year to arbitration. But as you might imagine, BIPA has created a new frontier for biometric data class action litigation. Fortunately for employers and companies, most states don't have similar statutes. Some, including Texas, Washington, California, New York, and Arkansas, do have laws that protect biometric data, or they have expanded recently existing laws to include the protection of biometric data. But in those states, it isn't clear that there is a private right of action, or the statutes specifically only authorize the state attorney general to pursue claims. Nonetheless, employers who choose to collect biometric data should ensure that they are familiar with the laws of the states in which they operate and know whether they need consent from their employees to collect that information. In terms of other risks, employers also need to be aware of just the regular old traditional tort claims like invasion of privacy. For instance, several years ago, an employee was terminated from her job in California because she disabled the GPS tracking device on her company-issued smartphone. Ultimately, the employer fired her for doing that, and she filed suit and brought pretty traditional tort claims, including invasion of privacy. That case settled, so again, we don't know what the outcome would have been, but there again, it just identifies the risk. Now, really significantly, employers who wish to collect this data or who happen to collect it just because they choose to use technology to improve operational efficiencies and so forth, don't have to use the data that they necessarily are collecting. Or if they choose to use it, they have a means of minimizing their potential exposure to liability. And that means is one that is familiar to many of us who practice in the HR and employment realm, and that is limit the access to the information to only certain people. Particularly if you are going to use the information in decision making, then be very thoughtful about who is provided with the access to the information and who needs to see it, and whether you really want to have those people have that information when they are making day-to-day decisions that are employment related. So we've talked about a lot of actual laws that protect privacy and apply, but let's talk a little bit about the law of unintended consequences. And of course, this is the old adage that teaches us to all be cautious when we're delving into something complex and unknown and we don't know what the outcome might be. So let's take the Hard Rock Hotel project in New Orleans as an example. The city of New Orleans installed GPS tracking devices in the vehicles that it had its inspectors for the Department of Safety and Permits driving around the city. Now, presumably, the employer or the company, the city of New Orleans, did this for its own benefit, right? To track its assets and to be able to monitor its employees' whereabouts. However, news outlets that have been investigating the hotel collapse have reported that information on the logs that were created by some of the inspectors doesn't agree with the information that is contained in the GPS data. Specifically, they have questioned whether certain inspections actually occurred on certain dates because the log says they did, but the GPS data shows that the inspectors weren't near the hotel site. That is an example of an unintended consequence, where an employer chose to invest and use technology for a reason for its benefit, and ultimately that information may be, or at least the news outlets have indicated that it could be used for the city's disadvantage. Another unintended consequence that we shouldn't overlook that relates to this is just the circumstance of losing that person-to-person contact in a workplace. You can envision a scenario, and there are workplaces now that are asking employees who arrive at the job site to put on a wristband so that they can track their activities as they move about the building doing their day-to-day things. Think of somebody who's a warehouse worker, for instance. And by using a device that you put around their wrist, you can see whether they're in motion and stacking and doing the things they're supposed to be doing throughout the day and monitoring their activities that way. What you don't need in that circumstance is a supervisor, a person, to lay eyes on these people and go around and see whether they're doing what they should be doing. You no longer need that person to direct their work necessarily. And so in that case, I think an unintended consequence could be the lack of this interpersonal connection that is very important to employees, the lack of the sort of pat on the back or telling people they're doing a good job, or just the interaction that gives employees and supervisors an opportunity to ask questions, get direction, and so forth. So if you're an employer and you want to use this data, you want to advance with technology, and you're necessarily going to be collecting data, what should you do? Well, these are my 5 takeaways for you. The first is be intentional. Be intentional about the type of data that you want to collect and know how you plan to use it. The second is obtain consent, particularly if you're collecting biometric information. Notify your employees and obtain their consent to use the information. You may also consider offering employees the opportunity to opt out of providing that information. Third, be transparent. Tell employees what data you plan to collect and how you intend to use it. In a different Gartner study, not the one that I referenced earlier, there was information that attitudes towards privacy are changing, like that individual I referenced when I was talking about the Washington Post article. But employees want transparency. Even if younger workers are understanding that data is going to be collected and shared, they still want transparency. They want to know how that information will be used. Fourth, of course, know the law. Confirm that there aren't any state or federal laws that prohibit you from collecting the information you're collecting or prohibit you from using it without requiring special permissions. And finally, make a compliance plan. If you do conduct business in a state that has specific laws concerning the protection or use of this data or limiting its disclosure, understand your retention and destruction obligations and limit your ability, and the limits to your ability to use and disclose it. So that's what I wanted to cover today. I don't know if anybody has any questions. Okay, here is one. One of you asked, you mentioned that employers need to be concerned about employees' privacy rights when using data that they can access, but you didn't discuss emails. To what extent can employers access information on employees' emails, including emails on their smartphones? So that's a good question. I didn't cover that topic because there's been a lot out there on emails over the course of years, but generally speaking, employers should have and usually do have written policies that entitle them and disclose to employees that information that they create and the use of emails on company-issued computers is information that can be accessed and reviewed by employers. And so generally speaking, employees don't have privacy rights in emails that they send and receive over company-issued servers. It is a more complicated question about whether employers can have any access of any kind to emails on people's individual smartphones, and that's a real danger zone and not something that I would recommend that employers do. There already are some cases out there that recognize privacy interests in that context, and it's hard to imagine sort of justifying what might be a really good business reason for needing to access that information. It's a good example, though, to make the point. A lot of employers do have technology that enables them to access employees' smartphones, but just because they can use that technology for one purpose, for instance, being able to wipe a cell phone clean if it goes missing, doesn't mean that the employers have the absolute right to access the information on employees' smartphones for other purposes, and they certainly don't without appropriate consent. Okay, another question. You mentioned that Fitbit has a Ready for Work app that allows employees to screen for symptoms of COVID-19 before coming to work. Can employers require employees to share that information? I believe the answer to this question is no. Employers can make a request that employees can offer employees the opportunity to do that. However, in the aftermath of COVID-19, there's been a lot of guidance from regulatory and administrative bodies that have indicated what employers can and cannot do. Here, the real concern is making sure you're aware of the Americans with Disabilities Act and that you're not making prohibited health inquiries or disability-related medical exams and that sort of thing. The regulators in the post-COVID world have said it's okay to temperature check, but that's really the extent of it. I think if you are an employer and you want to make known to people that Fitbit has a ready for work solution so that they can monitor and screen themselves, that's one thing, but I'd be very careful about encouraging employees to share that information with the company. Final question. In my business, we have both employees and independent contractors. Does the extent to which an employer uses technology to track the activities of its workers factor into whether the worker can be properly classified as an independent contractor? That is a complicated question. I think the answer to that is probably not. It doesn't fit squarely into what the tests are, and those tests have been changing, as you may have seen if you follow this. But it could apply sort of to the control factor, but to the extent that employers are more focused today on, or the law is more focused on evaluating the economic realities of a particular person's circumstances, the ability to track someone's whereabouts that wouldn't necessarily be determinative of that. I will say, though, that given how hard it is today to properly classify someone as an independent contractor, it seems much less likely that employers would be collecting data of this kind from independent contractors. So that's a good question. I think you'd have to look at that on a case-by-case basis to see whether this sort of information moves the needle on that analysis. All right, well, I think that's it. I appreciate all of your time today. If any of you have questions I didn't get to, please feel free to email them to me, and I'll be happy to do my best to answer them. Thanks.